A Minnesota transfer on death deed is a document used to convey property from a grantor to a designated beneficiary. This document allows the title transfer to happen outside of probate court upon the grantor's death. However, the grantor retains his or her right to revoke the deed at any time. In this video, we'll cover the difference between a transfer on death deed and a will, legal requirements for recording a transfer on death deed in Minnesota, and how to revoke a Minnesota transfer on death deed. We're eForms, the world's largest online database of fillable legal forms, and we're here to help you navigate the legal world with ease. To begin creating your own Minnesota transfer on death deed, click the link at the end of this video. We'll start by talking about the purpose of a transfer on death deed. How is it different from a last will and testament? Much like a will, a transfer on death deed can be used to convey property to a descendant. However, unlike a will, a transfer on death deed skips probate. What is probate? Probate is the legal process of assessing a deceased individual's debts and assets, and then distributing what remains. This sounds easy, right? Well, not necessarily. In Minnesota, probate proceedings can take 12 to 18 months, so your designated beneficiary could wait more than a year to inherit your home or property. That's why a transfer on death deed is so valuable. Okay, but how do you complete a transfer on death deed in Minnesota? Completing a transfer on death deed is pretty easy. You'll simply offer information like your name and the designated beneficiary's name. But one section that can be confusing is the legal description. A legal description is a written statement offering the precise location and measurements of the respective property. Formatting varies from property to property, so it's always helpful to reference your property tax statements or the current deed. You can also request this information from the county recorder's office. After completing the transfer on death deed form, you'll need to get it notarized. From there, you'll take the document to the county recorder's office in the county where the property is located. The county recorder's office will record the deed, making it official. This must happen before your death to be valid. But what happens if you record a transfer on death deed and then need to make modifications or revoke it altogether? You can revoke a transfer on death deed at any time before your death. To do so, you have three options. Complete and record an instrument of revocation in the county where the property is located, or complete and record a new transfer on death deed in the county where the property is located, or sell the home. Divorce or annulment will also revoke the transfer on death deed if the designated beneficiary is a spouse. If you want to get started on your own Minnesota transfer on death deed, click the link at the end of this video. Also, be sure to subscribe for more legal content.